And now with her guests, the attorneys who won the case. Ladies and gentlemen, here is Rachel Maddow. Good evening, Rachel.
Good evening, Keith. Thank you. And thanks to you at home for staying with us for the next hour. As Keith mentioned, pending traffic jams and such, we will be speaking this hour with David Boies and Ted Olson, the two the unlikely team of lawyers, of high-powered lawyers who successfully argued the case against Proposition 8. We'll be speaking with them in just a moment. In the past decade, 31 states have put to a vote the question of whether or not gay people should be allowed to get married. 31 states have put those minority rights up to a vote. And in all 31 of those states, that minority rights issue has gone down to defeat. In general, when you ask for a majority rules vote on minority rights, you get results like what we've seen on the gay marriage issue. 31 out of 31 times in 31 out of 31 states, voters voted it down. But here's the thing about rights. They're not actually supposed to be voted on. That's why they're called rights. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. No state shall deny to any person within its jurisdiction the equal protection of the laws, even if lots of people in that state want to. It's not up for a vote. Rights are part of the deal if you're an American. That's why the Equal Protection Clause is in the Constitution. In this case, specifically, it's in part of the newly controversial 14th Amendment to the Constitution. Rights are not supposed to be put up for a vote. They're not a popularity contest. They're supposed to be subject to a test of their constitutionality. That's why we have courts, not just to put people on trial, but to try the things the people say they want to be their laws. You try those things against the Constitution, and the Constitution restricts the things that Americans can make laws about, so those laws don't infringe on our constitutionally protected rights. That's sort of the big idea in this country. That's sort of the big idea that is this country. America, come for the religious liberty. Stay for the rock-ribbed constitutional guarantees of all your other rights. Today, for the first time in our nation's history, a federal court put the issue of a state ban on gay marriage to the constitutional test. The results were blistering. A federal judge in California ruled unequivocally today and in the strongest possible terms that California's recently passed gay marriage ban, Prop 8, is unconstitutional. The ruling's long, but it is a page-turner. Federal Judge Vaughn Walker summed up his ruling this way, quote, "Moral disapproval alone is an improper basis on which to deny rights to gay men and lesbians. The evidence shows Proposition 8 does nothing more than enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples. The court concludes that Proposition 8 is unconstitutional." And with that, California's gay marriage ban went kaput. A huge victory, of course, for gay rights supporters in that state and possibly around the country. But Judge Walker, who's a George H.W. Bush appointee, Judge Walker not only struck down California's gay marriage ban as unconstitutional, he also probably set the stage for what will be the next big court fight and the next big political fight. The anti-gay marriage side that was defeated in this case has already filed paperwork expressing their intention to appeal the decision. You should expect to hear lots of excerpts from Judge Walker's ruling, not only in the legal discussion, but I think you will hear it in the political fight that is sure to come as well, because I think many conservatives will see some of this language as explosive. Quote, that the majority of California voters supported Proposition 8 is irrelevant, as fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. Also, there's this. The evidence shows that the movement of marriage away from a gendered institution and toward an institution free from state-mandated gender roles reflects an evolution in the understanding of gender, rather than a change in marriage. The evidence did not show any historical purpose for excluding same-sex couples from marriage, as states have never required spouses to have an ability or willingness to procreate in order to marry. Rather, the exclusion exists as an artifact of a time when the genders were seen as having distinct roles in society and in marriage. That time has passed. The right to marry has been historically and remains the right to choose a spouse and, with mutual consent, join together and form a household. Race and gender restrictions shaped marriage during eras of race and gender inequality, but such restrictions were never part of the historical core of the institution of marriage. Today, gender is not relevant to the state in determining spouses' obligations to each other and to their dependents. Stick that on a bumper sticker.